Good morning, ladies and gentlemen. Are we ready to proceed? And are there any housekeeping matters? I ask you, Mr. Malou, first.
None from us.
Okay, thank you.
Not at this time, Mr. President. Thank you.
Okay,
Good morning.
thank you very much. Then we will hear the claimant's rebuttal, 30 minutes.
If I could just ask for a moment. Yeah, let's pass this on.
Can I see that for 1 second?
This isn't really the right title.
Thank you.
It's really about it protects both licit and illicit assets.
No, but that's not what I'm the point I'm making.
Okay, all right, I just want to make sure.
They're actually using it for a different point than it was originally.
Oh, okay, but why do you like that?
All right. Are we ready? Mr. President, are we ready?
I'm sorry, just a moment.
Okay.
I see that the real time is frozen, so I'm going to start the program again. So give me just 1 minute. It seems to be stuck on something.
Here.
We are ready.
I think we're waiting for the transcript.
Yeah, I'm sorry. The real time seems to be frozen up for some reason. Give me just a moment or two. Thank you.
If you want a cite for, Medellin relies on it too. Medellin 2 paragraph, it's slide 39.
Medellin 2.
Paragraph 20, I'll double check that now.
I am ready to go. Thank you very much for waiting.
Thank you, Mr. President. It is always most important to make sure that David is ready in the first instance. Members of the tribunal, thank you very much for your time over the course of the last several years that we've been before you. I suspect that today will be the last time I address you in person, so wanted to start with that. Thanks. And we appreciate the attention you've given us over the last several years because, as you know, we think this is a very important case. We do agree with respondent on that premise. It's an important case for many reasons. And it is kind of like what Ms. Banafitemi said yesterday. It has been two completely different narratives. Two ships passing through some body of water without seeing each other in the middle of the night. And here's the narrative that Colombia has given to us over the last few weeks and months. If we look at the first slide, we heard yesterday in the closing, in the particular region where the claimants have invested, that most of the land in Antioquia, where Medellin is largely in the hands of narcos, and their blessing, to put it that way too, if there's entry into the market, that's another barrier to entry. You need the blessings of the narcos to do business in Medellin. We also heard the only legitimate expectation, obviously, Mr. Seda and his acolytes should have been that by allegedly investing in Colombia, they are investing in one of the worst regions and the most dangerous regions. That's the narrative we have from that side. You come into Medellin, you come into Colombia, and it's not just a sign on the Meritage lot that says do not buy here, it's a sign at the airport when you get off the plane. One of the worst regions. You need the blessings of the narcos to do business here. Do not buy here. Do not do business here. That's their narrative. You should know better. And if you did diligence on a title and you didn't find anything, too bad, so sad, because someone at some point in time, you're in Medellin, you should know better. Narcos are involved everywhere. It's a barrier to entry to do business here. You got to get the blessings of the narcos. That's their narrative. No amount of diligence is ever enough because someone at some point in time is going to figure out that back in the 1990s, a narco was involved and behind a front buyer, and you didn't figure that out. Sorry. You should have Google searched, we heard yesterday. You should have gone around and asked folks. I don't know what the standard is. I don't know what the standard is. According to Colombia. And what we've told you is a different narrative. We've told you there is a standard, it's clear, it's not Google search and go to the ends of the earth and you can't do business here. It's actually not that at all. And that's why Colombia entered into this treaty. And if you go to the next slide, you can see on the preamble, the parties expressly said that at the beginning of the treaty, the first page. The goal was to attract investment, to move on, to offer alternatives to the drug crop production. How do you do that if you have a big sign on the door that says, do not come in, do not invest here? What we heard yesterday, I find it honestly shocking that the representatives of the government of Colombia are telling an international tribunal that they are investing in one of the worst regions. That's a quote. The most dangerous regions. That's the legitimate expectation you should have. No, that's not. The purpose of this treaty, everybody knew, we don't deny that there is a history of drug trafficking in Colombia. What we're saying is the way forward is to attract investment, to allow folks to come in and give them some legal security when they come in so that they can invest and make some money. Yes, it's not a bad thing to make money. It's not a casino. You come in, you invest, you take risk, you make money, and in the process you develop that economy. That is what the purpose of these treaties are. Those are the two ships passing through the night. And if I were to pick a narrative, well, you know which one I'd pick. It's not the one that says, do not do business here. It's the one that says, we have had a troubled past, but we want to invite investment so we can transition to a better future. That's the ship that I want to be on. And I hope the tribunal is with me. It's also the ship that the Constitutional Court of Colombia appears to want to be on. Because in August 2020, the Constitutional Court, it's the highest court in the country that resolves constitutional matters, said this. Before them was the question of what does it mean to to be a good faith buyer? And they said in a scenario such as this, people in legal commerce would be obliged, because this was what was being proposed, they'd be obliged not only to study the titles to the assets, not only the titles to the assets, but also to perform meticulous investigations into the legal past of the sellers, into the legal disputes that may have been involved in different jurisdictions, into investigations and inquiries carried out by prosecutor's office in which they could be involved, and even into opinions about the sellers in their communities and on social media. That's the Google standard. They were saying that's what's being proposed here, but that doesn't work. That's what the court said. They said the state has not determined the one aggravating factor of all of this is that normally the transfer of assets from lawful sources to third parties in lawful destinations and are acquired in good faith by persons who have profited from illegal activities occurs when the state has not determined the existence of illegal activities or the participation of such individuals in these activities itself. And if you were to adopt this approach, they say it makes legal trade difficult or impossible, and also imposes unreasonable and unsustainable burden on individuals, which go far beyond the duties of the legislator can constitutionally impose on them. As a matter of Colombian constitutional law, they said we can't impose this high burden. That would make commerce impossible. So that's the boat that the Constitutional Court appears to be on too. I see that the signal is lost. I don't know if, gentlemen, you have it in front of you, so I can continue. Okay. And so in response to all of this, what is... And then we have the essential security provision that they're relying upon. Nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary for protection of its own essential security interests. And then they say, but you have to look at the footnote. And the footnote says, the tribunal or panel hearing the matter shall find the exception applies if it's invoked. But there's two questions here. The first is, does the essential security exception apply? And they're saying that's a self-judging question. I actually don't care as much about that question. The second question is, but I'm going to come to, I will come on to it. For present purposes, the second question is, if it applies, what does that mean? What does that mean if it applies? And the footnote doesn't tell you what happens if it applies. But what it does not say, it does not say, if the exception applies, a tribunal shall not have jurisdiction, or you don't get access to dispute resolution. It doesn't say that at all. It actually says, it confirms the opposite. The tribunal shall find that the exception applies. But the question you have to ask yourself is, if it applies, then what? And that's the question that the Eco Oro Tribunal answered. But before I get to that, I do want to point to this next slide. They say there's a subsequent agreement, and they say it's non-justiciable. What is non-justiciable? What is non-justiciable? Because they put we added the blue box, by the way. The red box is what they've added. They're saying the Colombia and the United States agree that this question is non-justiciable. But if you look at what comes just before that, Colombia says the present dispute is non-justiciable. That's not what the United States says. They say the invocation is non-justiciable. That's the first question. Colombia is focused on the second question. So they do not agree about what is non-justiciable. Colombia wants you to adopt the position that this dispute is non-justiciable. You don't have the right to decide this matter. You have no jurisdiction. We're out if we invoke this. The United States is saying the invocation of this exception is non-justiciable. Those are different things. And if you look at, on the next slide, they refer to the US delegation round. Look at what the US says. There is a general concern that the general exceptions should not be abused. They should not be abused. This is a strong exception in cases of matters that have to be dealt with national security. The invocation of that exception is not subject to court review. But the question is, once you invoke it, then what? And that's where Eco Oro said, well, the then what is, you get to adopt your measures, but it does not mean you're exempt from the compensation obligation. So they say, but Eco-Oro was not self-judging, but that doesn't matter because we're in the second question now, right? In the tribunal in Eco-Oro is saying, okay, let's say it applies. Let's say this exception applies. But then what? If it applies, then what? And what they're saying in that case, very similar type of language for an exception provision. It doesn't really matter what the exception is, whether it's essential security or environment. But what happens then? They're saying it does not escape it just means that you can keep your measure, whether it's to protect the environment or your essential security or the health of your population, whatever it is, you can keep that measure in place. But if you've breached the treaty, you still have to compensate. So you don't get restitution, you don't get your property back, but you still have to compensate.
So the duty to compensate would, in that reading of 22.2 would not come from the measure itself, but from the fact that hypothetically it would have been applied in a discriminatory manner, it would not be consistent with fair and equitable treatment. Is that what you're saying?
That's correct.
How about indirect expropriation?
Yeah, likewise.
So if the measure is not subject to review, but it can constitute indirect expropriation, doesn't that make the measure effectively subject to review?
No, because an indirect expropriation is unlawful. It's only unlawful if it doesn't meet the 4 criteria, one of them being a compensation requirement. For an unlawful expropriation, where there is no compensation paid, right, the remedy under customary international law, under Charzau factory,
Right.
is restitution. You get your property back. If there's an unlawful expropriation that I was not compensated for, what happens under customary international law? The default is I get my property back. If I got paid compensation, it's not unlawful. If I got paid fair market value compensation, I have no claim before you, gentlemen.
But if the invocation of the exception, which is not subject to judicial review in and by itself, if that invocation results in the measure being excluded, carved out of the remedies of the treaty, normally afforded by the treaty, how is it that the treaty sort of comes back by the back door through?
Yeah, let me clarify. It's a good question.
Please do, because
Yeah, it's not all of the remedies. It's one very specific remedy. If we go to Article 22.2, which is on slide 11, it specifically says, nothing in this agreement shall be construed to preclude a party from applying the measures. That's it. So it doesn't exclude the compensation remedy. It just says you can apply the measure. And so what Eco-Oro said was, they said, what does that mean? So let's look at the Eco-Oro decision.
But sorry,
Which-
the measure, you can apply them anyway. Then if you apply them even without 22.2, the point is, if you apply measures that are inconsistent with the treaty, you end up being sanctioned under the treaty and you have to pay compensation.
You have to pay compensation, but you don't have to withdraw the measure. So what's
But
important?
you don't anyway, do you? I mean, if a state expropriates unlawfully, it doesn't have to give the property back. It should, but if it doesn't, it's going to pay up.
Well, as a matter of customary under the Articles of State Responsibility, generally, there are some exceptions for restitution, right? One of them being if it's impossible to give the property back. But the primary remedy is restitution. But I think it's important to remember that this Article 22 does not only apply to investment, it also applies to trade, right? And the remedy in trade context as well is withdrawal of the measure, right? If I have an embargo on certain, the importation of products, right? The remedy in the trade context is I have to lift my embargo. What this is saying is, no, you don't have to lift the embargo. There may be other remedies available, but the remedy of withdrawal of the measure, whether it's under the investment treaty context or under the trade context, is not available. And that's exactly what the Eco-Oro Tribunal said. They said Colombia also provided no justification as to why it is necessary for the protection of the environment, that's the measure, the purpose there, not to offer compensation to an investor for any loss suffered as a result of the measures taken by Colombia to protect the environment, nor explained how such a construction would support the protection of investment in addition to the protection of the environment. So they were looking at, okay, how do we you allow, in that case, the state to protect the environment, here it's essential security interest, but also achieve the objective of protecting investments. And they're saying you allow for the compensation obligation. And they specifically said in that case, accordingly, the tribunal does not find that in that case, Article 22013, it's a similar FTA situation there.
At the risk of being hanged, drawn, and quoted by environmentalists, do you and do we have to draw a difference between protecting the environment and essential security interests, or is it the same thing?
For
or does
present-
it boil down to the same thing?
In the context of the way these treaties are structured, it's essentially the same thing, because what states basically did was they carved out, they said there are certain things that are really important to us. And if they put environment at the same, they have, you can see, it says for the protection of human, animal, and plant health, parties understand to include environmental measures necessary to protect human, animal, or plant life and health, to ensure compliance with their laws. These are all, there was a list of things. For the conservation of living or non-living exhaustible natural resources, they can put whatever they want in the exceptions. And in the trade context, you know, in GATT, Article 20, it's similar, right? They've got a list of exceptions. So this is a thing that one finds, exception clauses in treaties.
May I ask, when you compare the Canada-Colombia FTA, in the introductory sentence, there's a subject to half sentence, which is not in Article 22 of our treaty, namely subject to the requirement that such measures are not applied in a manner that constitute arbitrary or unjustifiable discrimination between investment or between investors. So what does it mean for the interpretation of Article 22 that there's not such a subject to language?
That, in my reading of the ECOOR decision, does not factor into the tribunal's decision, because what the first part of that sentence says is are not applied in a manner that is constitute arbitrary or unjustified discrimination, right? So it's just talking about those two things. But in the ECOOR decision, they don't just say, okay, we're just going to assess whether or not your conduct was arbitrary or unjustifiable discrimination. They talk about breaches of FET, they talk about breaches of the other provisions of the treaty. So they're not just saying you're limited now to the question of arbitrary or unjustified discrimination, that's not what they did. So if that had a bearing on their analysis, then presumably they would have said, okay, you're then limited to whatever this clause says. But they said, no, no, no. What this is saying is you can adopt your measure, but it doesn't exempt you for the compensation obligation with respect to breaches of the treaty.
I apologize, just to say that I'm frozen.
Me too.
All of them are, something's going on with the Wi-Fi. It just keeps going in and out. Do you want me to fix it right now?
It's possible.
I can fix it right now if you give me a minute or two. When the Wi-Fi goes in and out, it disconnects everything. Can I take a minute?
Mine is frozen.
Raheem, a couple of things. My angels singing a poem or asking them for money. This is why. No. Just they're gonna get into the wiretaps. So if Angel's asking them for money, it's because they agreed that they would defend.
Okay, I got the real-time working now, but I have everything, nothing is missing out of the transcript, just only on the real-time. So from this point forward, it'll be on until the next Wi-Fi outage.
Okay. If I may? Please.
Now, Article 22 is sorry, I had it here and I just so Article actually the whole of Chapter 22 are exceptions, and you're saying that what the exceptions mean is that if they apply,
I've got it right here.
then the country, the state, gets to keep the measures, no more. So what are the exceptions to then? Why are the exceptions? Exceptions to what? I mean, I understand sort of your argument, and this is my understanding, you may correct me if I am wrong. When you look at the expropriation provision, the fact that an expropriation is done as it must be for a public purpose, and it can be, you know, the greatest purpose. The Santa Elena case comes to mind. It was to protect, if I recall correctly, turtles. So that's, you know, it's a perfectly valid public purpose, and it's good for the environment, and it's good for the turtle, and the turtle is in conservation. So the fact that that is the object of the measure doesn't exclude compensation. If it's an expropriation, even if it is to protect the turtles, then that requires compensation. So I understand, you know, sort of in that context, that expropriation would be required. But if it is an exception to the treaty, you were saying that in the trade context, it's just, you know, the remedy is you get to keep the measure. I would disagree with that characterization. If it falls under the exception, then there is no wrongfulness in terms of the ILC articles. If the exception applies, although there might be a prima facie violation, it is covered by the exception, so there is no international unlawfulness. And if there is no international unlawfulness, what would be compensated? That's what I don't understand. Now, just to take it back to the trade context, what happens in the trade context ultimately, because there is no international police, a country always gets to keep the measure if it wants to. Not without consequences, but if it wants to.
Countermeasures, right.
And there are several countries that have gone down that road, and then the remedy is countermeasures.
Correct.
Whether regulated countermeasures, as you know, suspension of concessions or other obligations, or countermeasures under the ILC articles. That's a remedy. If it falls under the exception, it's not that the state gets to keep the measures. There is no basis for countermeasures, for the other remedy in case the state, as sovereign, decides, I'm going to keep the measures in any event. So, again, if it falls under the if it doesn't exclude compensation, then what's the purpose of the exception to begin with?
So I understand your question, and I think it's really important to look at the treaty language, because the treaty language does not preclude a wrongful action. It does not say that if this exception applies, there is no breach of the treaty. There are treaties that exclude the tribunal's ability to decide a matter generally. Like there are other treaties that have language that reflect more along the lines of what you're suggesting, Mr. Periscano. But this treaty does not do that. All this treaty says is if the exception applies, it means that it doesn't preclude the party from adopting the measure. So I would say in the trade context,
But again, what's it an exception to?
let me use your example of the trade context. My suggestion, in my interpretation, would be that the state does. I accept that sometimes states don't withdraw their measure, but that is the primary remedy. This is saying you don't have to. You don't have to withdraw your measure. It's not. When the WTO, when a tribunal says, a trade tribunal says, you must withdraw your measure, that is what they're being ordered to do. Here, that cannot be the remedy that a tribunal orders.
But a remedy to what? If the exception applies, there's no remedy.
The exception does not apply to the breach. It applies to the remedy of applying the measure.
Can you?
It doesn't say breach. It says to preclude a party from applying a measure. So this is precisely the language.
Well, I don't think, I haven't looked recently at the whole of Chapter 22, but I don't think that any of those articles say, in case of breach, then the exception applies. That would be an odd formulation for exceptions. I don't think I haven't seen any treaty where that language would come up. I think exceptions are drafted generally as they are here in Chapter 22.
That's not what it says.
Yeah, I think you're right that exceptions often appear this way. And so in the trade context, for example, I don't think it would be right to say that so if a state adopts a measure to protect, in Santa Elena, it was leatherback versus Costa Rica, it was leatherback turtles. I think it was a property development on the beach. And if they're going to protect leatherback turtles on the beach, or in the trade context, if they prevent the they say we're not going to import, we're going to apply tariffs, right, to a particular product. They're allowed to do that if an exception applies. But does that mean that the foreign state has no remedy, that their goods are now subject to a tariff, but they have to let in the other country's products tariff-free? Is that what it means? That to me would be undermining the purpose of the trade agreement, right? So I think it would, what in the trade context I would say, what the answer would be is, okay, you can keep your tariff because the remedy cannot be that you have to withdraw your tariff. But that doesn't mean I don't get to put in a countermeasure. I get to put up a tariff too. So what Eco Oro is saying is you have to look at the purpose from the perspective of what is the exception trying to do. It is trying to protect, it is allowing the state to apply its exception, whether it's to protect leatherback turtles or an essential security interest or the public health, right? But you also have to protect investors' investments. That's another goal of the treaty. And as the United States said, it was they wanted to make sure that this exception didn't undermine be basically a gaping loophole for the investor protections. That every time a case comes up, they just say, "Oh, we put our hands up. We say this exception applies. We're out. Basically, get out of jail free card." Right? To avoid that, tribunals like Eco Oro have said, "Well, fine. You can adopt your measure. You can, in the trade context, you can put up your tariffs, but that doesn't mean that the other side doesn't have a remedy. That remedy just can't be, the remedy ordered just can't be withdraw your measure." So that's one of our 4 submissions on essential security. And I do encourage the tribunal to read the Eco Oro decision because it was under the Canada-Colombia FTA, so also involving Colombia, which has, it was an Article 22, there was an exceptions provision like this. There's a debate about whether this one was self-judging and that one is not, but I don't think that affects this analysis that we're undertaking right now, which is what is the consequence of it applying, whether self-judging or not. And the tribunal went through, and considered Canada's disputing party submissions. Canada came in and they said this is what it means, much like the US has done here. And the ICO-ORO Tribunal went through that in some detail, and I think it's a helpful analysis. So I do encourage the tribunal to read the ICO-ORO decision. I have no doubt they will. But I think another important point here with respect to the essential security provision is the timing of when it is that the essential security interest must come up. Because from the language of the provision itself, it is clear that the essential security interest to be protected must be known at the time that the measure is adopted. You can't say, I'm adopting this measure. I am going to take your property from the beach, as in Santa Elena and Costa Rica. I'm not going to let you develop your tourist development in the beach when there's no concern about leatherback turtles on the beach. And then 10 years later say, oh, now they're leatherback turtles. So what I did 10 years ago, I'm going to rely on something that happens 10 years later to justify an action I took 10 years ago. You can't do that. The essential security interest must be known and must be the reason why you adopted the measure in the first place.
If I adopt as a state, I adopt an asset forfeiture law that aims at assisting me in the fight against organized crime, and particularly a type of organized crime that puts into a question the very existence of my state, isn't any measure adopted in the context of this asset forfeiture by definition something that relates to an essential security interest? And do I really have to invoke it before I take the measure, or even afterwards, actually?
That's not Colombia's case. Colombia's case is they didn't know about their essential security purpose until the rejoinder, and that's why they brought it up late. If you look at our opening slides, I don't know if you have them, but this might be of assistance.
Which one?
It is.
I think we are aware of that argument.
Yeah, it's the, yes, we can get it for you, the specific reference. But basically, they said that they didn't have this essential security purpose and they didn't know about it up until before the rejoinder. So it is not, their case is not that any application of the asset forfeiture law is, would implicate the essential security provision.
I'm aware of that, but isn't that a possible line of approach to the problem?
If it was legit, I mean, we'll get on to the good faith application, but I don't think they can just wave their hand and say, this is for essential security, and so tribunal, you have no more job here, right? Because it would just not be a good faith application of the provision, and I'll come on to that too, but I don't think they can just wave their hand up in the air and say, we show up to this tribunal, we're invoking this exception, you're out. Because then what's the point of the treaty? We might as well rip up the treaty, because every time they get sued, they'll show up and they'll say, I'm out, essential security. That's what will happen. And if you look at the Nicaragua versus US case, that case involved a treaty that had they specifically dealt with this question of timing. At what point in time do I need to invoke the essential security? Do I need to know my essential security concern? And there they specifically said it must have been at the time the measure is taken. That's what the ICJ says in the Nicaragua versus US case, which makes sense. If you're going to apply an essential security exception, if you're going to take a measure to protect your essential security, if I'm going to take a measure to protect my society, I have to know that I'm taking that measure for that purpose. I can't take a measure and then 10 years later try and post hoc justify it. That's not what the essential security provision is there for. And it does relate to the good faith invocation of this provision. And if we go to the next slide, there was a question that was put to counsel for respondent. What is their position? Can you just invoke it? I think Dr. Ponce, you asked counsel for Colombia yesterday that question. Can I just invoke it at any point in time? And I wasn't quite sure what the answer was yesterday, but I will tell you what the answer was in Colombia's rejoinder. And it's up here on, sorry, we can go back to our slide 15. It is the respondent's submission that the tribunal's scope for review of Colombia's invocation of the exception is strictly circumscribed to an examination of whether the exception of essential security has been invoked in good faith. So they accepted in their rejoinder that this tribunal has the authority, the jurisdiction, to assess whether or not it was invoked in good faith. That is accepted in their rejoinder. And both parties cite to the Russia measures concerning traffic in transit case with respect to what that standard is. And there's two aspects to that standard. The first is the definition of the essential security interest in and of itself. And I would say if they could not define the essential security interest at the time that they invoked the measure, that is not a good faith invocation or defining of the essential security interest. But the second is the measure at issue must meet a minimum requirement of plausibility in relation to the preferred essential security interest. And so it must be connected. There must be a connection between the essential security interest that's being invoked and the measure that's being adopted. And what we would submit is if you are going after good faith third parties, which the asset forfeiture law itself protects, then by taking a property from a good faith third party, that is not a good faith invocation of an essential security provision. So it's twofold. There's the question of timing. At the time that I took the measure, did I know? Was I doing it for that reason? And they themselves have said, no, we didn't know at that time. We didn't know until the rejoinder. And the second is, are the two connected? Was this essential security interest met by invoking the measure? And we would submit if you are taking property or an asset or an investment of a third-party good faith purchaser, which the law that you're invoking itself protects, then that is not a good faith invocation of the essential security protection. And that is something that Colombia and us accept you are able to look at. You know, I did say at the beginning of yesterday, I wasn't sure what we were going to hear yesterday afternoon, whether we might hear a new objection. And sure enough, we did. We heard an illegality objection for the first time yesterday. Closing submissions. Now, here's the slide, the first slide, ICSID Article Rule 41.2. That should set off alarm bells. Because when was the last time we saw that? The last time we saw that was when we saw the late admission of the essential security defense. And it says the tribunal may, on its own initiative, consider at any stage, apparently, after the merits hearing, at the closing submissions, you can now consider this brand new defense of what? Of illegality. That the investment has been made illegally. They were telling you throughout the submission that there's been no wrongdoing by the claimants. That's a direct quote from them. You saw that yesterday. We put up that quote. They said claimants have done nothing wrong here. It's not the claimant's wrongdoing. We're going after the asset. But now they're saying that the investment was made illegally. Well, I don't think I need to say much more than to say that is clearly out of time. And if the tribunal is going to consider it, we would reserve our rights. But, you know, you open one door, and if you let them go through that door, the respondent's going to look for another door. And we're going to be walking through doors forever. We're never going to finish this proceeding because every time we show up before you gentlemen or have another pleading, there's a new argument, a new defense. Now, members of the tribunal, I know there's been a lot of questions. I want to be helpful to you, but I also am cognizant of time. So now's an appropriate time. I don't think we need to take a break right now, but I just want to make sure from a time perspective how you want us to proceed.
Well, you have 5 minutes and a half remaining, and the tribunal has spent 25 minutes in questions.
So I know we have separate time reserved this afternoon for questions, but I'm in your hands, Ms. Banfatemi. I want to be helpful to the tribunal. If they're going to continue to interject with questions, I'm happy to continue answering questions, and likewise, with you this afternoon,
Why don't you go through the remaining part of your? Sorry. Why don't you go through the remaining part of your rebuttal, and we will then have the break.
Okay.
That's perfect, Mr. President, and I know that the tribunal had reserved 1.5 hours, so whether or not the tribunal asks these questions now or later, that doesn't make much of a difference, so we're completely in your hands.
Okay. Thank you, and obviously, we'll just proceed in the same way with you. Thank you, Ms. Banfatemi. If there are no more questions on essential security for the moment, and I'm happy to take any, I'll move to discrimination. Now, we've talked obviously a lot about discrimination in this case, and in my mind, I have not seen a clearer case. One of the key questions in discrimination cases is oftentimes, are they in like circumstances? Are there similar cases? It is almost impossible in my mind to view a case where that cannot be in question, because you literally have a sister property with the same alleged deficiencies in the history of title, and the two were treated differently. And one of the questions that was asked by President Sachs yesterday was, and I think this is an important point, so I wanted to clarify it, is, and let me take a step back. We talked about these two studies that they had, that Ms. Ardila Polo had when she was making her assessment. And we said when she made her assessment, she had one on the sister property and one on the meritage, and she took action against the meritage and not the sister property. And one of the questions, Mr. President, you asked, which is a good question, did Ms. Ardila already have in hand the legal opinions to the title search at the time? And then the question was, at the time of the precautionary measures? And President Sachs, you said yes. And Ms. Herrera said no, she did not have them at that time. But on cross-examination, she answered this very question. But she answered it differently. Ms. Champion said, you had these two title studies, including the title studies performed by the two law firms, Otero and Palacio, that's the meritage one, and Guzman Monroy. Ms. Ardila said that she had those two. She says, I have the Otero and Palacio and the Guzman and Monroy. And Ms. Champion asked, to clarify, at what point in time did you have these studies? So you had the Otero Palacio title study before you imposed precautionary measures. And she said, that's right. So she was talking about these two title studies, having them before she imposed precautionary measures. So the answer to your question, according to Ms. Ardila Polo, did she have these two title studies before she imposed precautionary measures? The answer is yes, she did.
But
what we have for you here is, in this section, every provision that we could find in the asset forfeiture law that refers to good faith status. So for your reference, it's there. The first provision deals, and they're not in order, but they're all there, deals with affected persons. These are the folks who have a vested interest. They're the ones whose good faith status matters. That's Article 30. We asked the question, what is the relevant date at which good faith must be assessed? And Dr. Medellin and Dr. Martinez have both answered that question as saying October 2013. And why do they say October 2013? I think that's an important question. It's because that October 17th is when this pre-sales trust agreement was signed. And on slide 27, you can see that agreement. And that agreement makes it clear, it's the administration and payment trust. Both of these agreements were signed on that date, and the Administration and Payment Trust makes it clear that as of that date, the contract is irrevocable, and the trustor may only modify it or change the use of the assets in trust with prior written approval of the purchasing beneficiaries. The purchasing beneficiaries are the unit buyers. So that matters, right? Because As of that date, you're now selling units to unit buyers. So as of that date, it's irrevocable. You can't, it's the point of no return. So that makes sense. Your good faith should be assessed as of that date because as of that point, you can't give it back. You're now selling to unit buyers. So if you discover something at some later point in time, you're stuck. You're stuck. You now have obligations. So that's why Dr. Medellin and Dr. Martinez say that's the date, because that's the point at which you have vested acquired rights, and it's the point of no return. It's an irrevocable obligations at that point. Article 3, which is at the very beginning of the asset forfeiture law, makes it crystal clear. Asset forfeiture shall have as its limit, the right to ownership legally obtained in good faith without fault. So they say, you know, it doesn't go after people, it goes after the asset. We agree, it goes after the asset, but there's a limit to going after that asset. You can only go after the asset insofar as it does not affect the rights of good faith third parties. So it is an act, you're going after the asset, yes, but you can't go after the asset when it affects the right of an affected party who is a good faith third party. There's a presumption of good faith. That's Article 7. Whose burden of proof is it? It's the Attorney General's burden of proof to assess good faith. And they say, oh, but this is their burden of proof in court. But it's like any prosecutor's burden of proof, right? You don't bring the action to court unless you feel like you can meet the burden of proof that's on you, right? The standard of proof. And so the burden of proof is on the Attorney General. That's not in dispute. At what point in time in this proceeding do they have to assess good faith? This is Article 118, sub 5, that President Sachs, you were asking about. They must search for and collect the proof. They didn't search for and collect the proof. They had these title studies and treated two differently, but they didn't go and search for they had nothing else that we know of. They didn't ask certainly Newport about any of the steps that they had taken during the initial stage. And what is that initial stage? It's the point up to the provisional determination. That's the determination of claim, which happened January 25th. That's usually the initial stage. But there's an exception, and that is when precautionary measures are taken. Precautionary measures may be taken urgently during the initial stage, but even then, Article 87 makes clear that when you're taking early precautionary measures, you must still do so. In any case, the rights of third parties acting in good faith without fault must be safeguarded. And Dr. Medellin explains this. He says the imposition of precautionary measures requires the greatest care, given that their duration, depending upon the duration of the asset forfeiture proceeding, might extend over time, generating possible harm to persons who are able to demonstrate their status as good faith third parties without fault. If we end up getting stuck in an asset forfeiture proceeding that's 6 years long, that's what he's talking about. You have to assess their good faith and protect their interests, because otherwise you get stuck in this proceeding and that's it, you're stuck.
Sorry to interrupt again, but it's not fully clear to me what happened in this case at the expiration of the 6 months period, which is quoted on your of Article 89, which is quoted in your slide number 32.
They issued a
Go ahead.
They issued a determination of claim saying that asset forfeiture should take place. That's what the Attorney General's office decided.
And then?
And then it went into a court process where it is currently stuck.
So other than the judicial determination that the measure was in principle justified, there is nothing, is what you're saying?
It was a prosecutorial decision.
Okay.
That determination of claim is made by the Attorney General's office. The determination of claim was filed by Ardila Polo. It was an administrative act. And then the next step is the recorriamento, which was Ardila Polo was unceremoniously fired or moved or whatever between the determination of claim and the requerimento. They were documents that were issued about 1 month apart. Dr. Caro was asked about this on cross-examination. He basically copy-pasted the determination of claim and adopted it as the requerimento. He said, I have 120 cases. You may remember this from the cross-examination. And as soon as he got hired, he basically said, I just ignored my 120 cases, and for 1 month straight, I did nothing but do this requerimento. That's what he said in cross-examination.
So after the 6 months period, and to this very day, we have an asset forfeiture procedure that is in limbo.
Correct. And just in 2022, the affected party status of Newport has now been recognized. And what have we been told? We've been told, well, now we'll wait and see how long it takes, but now they may be recognized at some point. And their good faith status may be the courts, because the prosecutors didn't do it, now the courts might do it. And what happens then? They get the property back? But that's still a breach of international law because it's too little too late. This claim is not premature because that investment is dead. It is gone. All of the other projects are done. And that's why Dr. Medellin says what he says. You have to take the greatest care before you do this. You have to assess good faith party at that early stage because of this, because it can get stuck because of their duration in these asset forfeiture proceedings for years. And I asked Mr. Caro, before he did the requerimento, did he assess good faith? So I asked him, did you do this during the initial stage, right? Because this is what he's required to do. Did you assess Newport's good faith? And in cross-examination, he said he assessed Corfi Colombiana's good faith, but not Newport's, is what he basically said. What is the good faith standard? What must you do? We've talked to you about the Constitutional Court decision. I won't go into that in any more detail, but it's not the Google search standard that you heard on the other side. And you have the slide from yesterday saying, well, if they would have searched for Ivan Lopez, even though he wasn't on title, to be clear, what was Ivan Lopez? He was a legal representative at one point in time. This is important to note of Sierra Alta. At the time they did the search, he was not the legal representative of Sierra Alta. That's why he didn't turn up. That's why he wasn't on the list. The legal representative at the time they wrote to the Attorney General's office and said, please search all of these people, was Sebastian Lopez, his son. And they did search Sebastian Lopez. But Ivan Lopez was a legal representative at an earlier point in time. So apparently you're supposed to search all the owners, all the current legal representatives, and all of the prior legal representatives is what you're supposed to do. You're supposed to Google search all of them. Mr. President, did you have a question? Or, okay. And the Google search standard, I don't think I need to deal with in any further detail, but obviously there would be a whole bunch of mischief that would happen. Commerce would come to a halt. If this tribunal finds that the standard is anything other than what the Constitutional Court decided, then it would be havoc, I will say, in Colombia because business will come to a halt. No one will buy and sell property if this tribunal finds that that's the standard. You see that Dr. Martinez, and if you look at Medellin's second report at paragraph 70, also confirm that the standard is what this Constitutional Court decision says it is. And instead on slide 40, you can see 39, you see what standard they would like to rely upon on Colombia. And they rely on a case from the Court of Antioquia District, but I think it's important to recognize that this is not an asset forfeiture proceeding case. This is a case under the Victims' Land Restitution Law. So to be clear, this case that they rely on that side is not an asset forfeiture law case. It is a victims' land restitution law case. and therefore does not apply. You are well aware of the, and by the way, it's also not the Constitutional Court, which is the highest constitutional court of the country. It's a lower court. You're well aware of the diligence that was done, but there's only one point that I wanted to emphasize. They say, oh, they only did, the Otero Palacio, they only did a civil title study. They also did a corporate study, and Ms. Champion took you through that yesterday, on their counterparty, on La Palma. So it's not just a title study that they did a corporate study, and Ms. Champion gave you that citation yesterday. Dr. Medellin and Dr. Martinez both looked at this case, and they said, as the father of the asset forfeiture law and the one who drafted this law, they looked at it and they said, would Newport have qualified as a good faith purchaser? And the answer for both of them independently was yes. Based on what I've seen was done in this case, I think that sufficient steps were taken to make them good faith third party purchasers. At any point in time, the Attorney General's office has the right to withdraw an action against a good faith party without fault. That's 124, paragraph 4. But they haven't done that in this case. And I think this last section that I wanted to take you to is important, which is Article 16. Forfeiture shall be declared under the following circumstances. 10 is particularly interesting here. Yes, forfeiture goes against assets. But even assets of legal origin can be taken when? Assets of legal origin whose value is equivalent to any assets described in the preceding numbers can be subject of asset forfeiture when? Whenever the action is inadmissible due to the recognition of the rights of a third party against acting in good faith without fault. What does that mean? It means that if I were to act against an asset that would affect the rights of a third party good faith, third party without fault, I can't act against that property. Instead, I go against the property of the wrongdoer's licit property, their lawful property. I can go against that property because what I can't do under any circumstances is affect the rights of a good faith third party. And that's what Article 16.10 allows them to do. It allows them to go against lawfully obtained property of a wrongdoer if going against the illicit property would affect adversely the rights of good faith third-party purchasers. And that's exactly what Dr. Martinez and Dr. Medellin talk about in their report. That's what should have been done in this case. If they identify a good faith third party that's being affected, here in Newport, and by the way, the unit buyers, but if there's a third party whose rights are being affected, if I go after this particular asset, what I do instead is or Ivan Lopez's other assets. That's what you're supposed to do. So you don't, under any circumstances, affect a good faith third-party purchaser. Sorry, did you have a question, Dr. Ponce? Okay.
I was mumbling to myself that this is very similar to the Italian provision.
And many jurisdictions have something similar. Even though it's against the asset, you can't go after the asset if it affects the rights of good faith third parties. You can then go after other assets. What I want to end on, if in just a couple of minutes, because I don't think there was any real rebuttal to our damages case in this case, quite frankly, is a few of the points that were made at the end of yesterday. The first thing I wanted to address is that this causation question. There's more than enough documentary evidence, I think, that this has affected Luxay and other properties. They say very carefully in their closing presentation, there's no documentary evidence that Colpatria pulled their funds from Luxay. But Mr. Lopez Montoya and Mr. Seda confirmed this in their testimony, and Mr. Seda was not questioned about it, and Mr. Lopez Montoya, who's the VP of construction, and obviously very well positioned to be able to answer this question, testified to this. There's nothing in the record that questions that evidence. They talk about, Paladin was still interested, and they refer to a couple of emails. And you can see they refer to C379. They said Paladin was still interested. But let's look at that email. It's right there. Paladin writes to Mr. Seda on August 8th, 2016, 5 days after the asset forfeiture, of the seizure, I should say, of the Meritage, and he said, understood. We would have to wait until the Meritage issue is resolved to move forward. That's with respect to the Luxe. He's talking about his investment in the Luxe. But I do not see a problem with continuing the relationship and learning more about Luxe in the meanwhile. But he's making clear, yes, he's still saying, okay, we'll still talk, let's see what happens. But we're gonna have to wait to see that this Meritage issue is resolved. So it is misleading, quite frankly, when they say the claimants tried to obtain alternative financing or tried to sell the project, and emails from Paladin, if you look at them, you'll see that, in fact, there were third parties that were still interested. Well, no, they're saying, okay, let's carry on the conversation, but we have to wait for this Meritage issue to be resolved before we invest in Luxe. That's what that email actually says. DCF is appropriate here, and even if you apply the Rusoro test that they put up, all of these, I explained to you yesterday, are satisfied. You have to look at this enterprise as a business, not just the Meritage project in isolation. This is the Royal Realty Property Group, had dozens of employees that worked on all of these projects. They were working on Luxe, on the Charlie Hotel, Mr. Lopez Montoya, Mr. Seda. It was the same people that were working on this. It was a business. It was not just one. You can't look at it as just one project that was affected here. It was an entire business that was adversely affected. And that enterprise had a history of financial performance because of the Charlie. This is unlike there's a track record here. Are there reliable projections through business plans? Yes. BRG relies on those business plans. If you go through each and every one of these, we have satisfied all of them, and Rusoro says you don't even need to satisfy all of them, but I think we satisfy each and every one of them. And like I said, this is unlike, real estate property development cases are unlike mining and other cases where there's all of this uncertainty. Real estate has inherent value. Once you have the contract locked in, once you have financing in place, this project is a go. You pre-sell the units, you pre-sell them. The last point I wish to make is just to deal with these concerns that they have that we're pursuing actions in domestic courts. Well, we can assure you, just like they have in other cases, that we can provide whatever undertaking this tribunal requires, that we will not double recover. It's a matter of international law. There are certain rights that obviously our clients have, and those are the ones that are being pursued before this tribunal, and that's perfectly acceptable. And other tribunals have dealt with similar situations. And this whole idea that money, if you award the claimant's money,
Budget, Sarah.
Would you like me to tell the additional minutes that they spent?
Yes.
Or? Yes, 19 minutes.
So 49, instead of 30, 49. Okay, so the same budget is of course available to the respondent.
Thank you, Mr. President. And before we depart for the break, my partner has a question for Mr. Malou.
Thank you, Mr. Malou. You made a reference when you were showing us the titles that you stated you said that Ms. Ardila Polo had received, and you say, we can give you the reference. I will be grateful if you can give me the reference.
Understood.
Thank you.
I'll send you the page number of the cross. I think she said she got it from the.
I don't mean of the cross, because that's clearly you put it in the bundle. What Mr. Malou
I
said.
think it's in the cross where she answered the question.
Yeah, she
We'll
said
give
that-
it to you.
No, not the question. You say we can show you the reference to the where you
Where she
take
got
the
it from.
basis that she got it and when she got it.
She says in her testimony that she received it from the organized crime prosecutor.
We can give you the reference.
Okay, thank you.
Yeah.
Thank you.
But if you look at that page of testimony, it's clear. I think she got it from, what's her name, Marisabel Correa Torres? I believe
If
so.
you send it, that's great. Thank you. Thank you again.
Now it's 11:05 or 11:08.
Yeah, I know.
Can we resume?
Let her-
We said that we would give you some more time, so a longer tea break, let's say 11:45, would that be all right?
It's 11:09 at my watch.
Yes.
So 11:45 would be. I'm sorry. I had noted, Mr. President, you would give us 45 minutes. So if the tribunal agrees, we're now 11:10, 5 to 12 or 12.
5 to 12, yes.
5 to
Okay,
12?
5 to 12.
Thank you.
Okay.
I'm fine, yeah. Yeah. Jimena, look at page 848. 848. Of the cross. Of the cross.
That's where it is.
That's where it is. She says prosecutor number 24 gave her the file, and it was in there. Do we have the materials that organized crime prosecutor gave her? I don't know.
No.
If you gave them to us, we do.
No, that's not my question. My question was after you say, I don't need the reference.
That's the reference. That is the reference I was referring to.
Oh, okay, I got you.
Thank you. I thought there was some other document. Thank you.
Totally. And that's what happens with the unreliability factor. Yeah. It affects the real time out to all of them and they can't. So, but now here it is. 70 pages. I don't know, this. So I just sent them the rough draft. Yeah, now that's fine. It's happening. And all of a sudden you hear during the break, oh yeah, we did have a call back. First before he shoot.
It's raining, it's recording about, I'm afraid that I shoot for the head.
Yeah.
I must admit, I'm guilty of shooting for the head.
Oh, it's crazy.
I
Just makes me big.
shoot obviously for the next training. I was by,
Well, we're gonna take a lunch break probably after the next. Us too? Okay, give me a few minutes. Well, we'll see. I mean, this thing went on over 2 hours. Almost 2 hours.
yeah.
So he needs to come on. I'll take you right up to 1:30, 2 o'clock.
I will be reading the whole.
No, I'll say goodbye to you. Don't worry, we've got a short break now, so a half hour more. Yep. I'm exasperated. Oh, God. That's why you didn't see real time coming up. Look what I got now.
Oh, you got it. So I just want to ask you a question. Do you know if you can export this to print?
To all departments.
Just could you send it to me?
Well, tell me what your email address is.
It's C as in, right.
Rodriguez. That's it, at GPSdisputes.com.
Yeah, if there are other email addresses from the team you'd like to put in, I will.
I think that one's.
Okay, I will do that.
Thank you very much.
Hey, you're welcome. I'm gonna go ahead and send this.
Thanks.
Yeah.
I knew you missed the tables.
Yeah, I can go with it.
You missed the tape and the tables.
Well, see what happened here? My Wi-Fi went out. It jumped the entire transcript. And they're all looking at me like this. Well, he's got a hard wire. You have a hard wire?
I'm
Yeah.
connected with
Yeah.
How come you can't do that?
Well, I can now.
Oh, brilliant.
Yep. But I didn't pay attention to it yesterday like I should have in order to put the wire in, or let alone
Well,
find the
shame
wire.
on you.
Yeah, so.
You should have done.
I swear to God, I need
You're
a
like,
tire
look,
from
you're
this
like,
business. Huh? I thought it was paradise. Good, a DC.
Oh, what was it he was saying? It was one word that he kept saying, wrong, said it wrong, so many times.
Not just one word.
Oh, what was it? La oficina. La oficina. It's la oficina.
Yeah, Abyssinia. I know it's something like Abyssinia.
Oficiana.
Or how about Abyssinia? Ancient
Oficia-
Syria.
It was Oficiania, he was saying.
Oceania. Oceania.
Oh,
Oceania.
yeah, it became something completely different. And I don't know what a leatherback turtle is in Spanish. So it became a turtle. Una tortuga. ¿Cómo se llaman esas tortugas? Son tortugas de agua, las que, ¿sabes? Las que viven en la playa y...
Tortugas marítimas.
Ah, pues son tortugas. Según mi interpretar, son tortugas.
Yo recuerdo un caso de una tortuga, creo que era de Perú.
No recuerdo, pero vivían en la playa y entonces se confiscó la propiedad
Me
por
acuerdo
las
ese caso.
tortugas. Pues son tortugas. Se llaman leatherback turtles, pero...
Sí, eran tortugas marinas.
Ah, ok. Bueno, a eso se refiere, tortugas marinas. No son las tortugas estas que encuentras en el jardín.
No.
laisse derrière apparemment.
Because I have some issues with the speakers. One Seda.
It was a little too fast. Okay, so we have it here. What is your email again?
It's Leandro. ICSID.com. Yes, thank you.
I will send it to you right now. Oh, there you are. You got a cute little picture.
It was at one of my best friends' wedding.
Yeah. How long ago?
Just before the pandemic, February 2020.
Now it's called first part.
Debería ser así.
Was Sam Kennison at that wedding too? Was Sam Kennison?
No. yo como no despacho, no lo puedo subir. Claro, yo tengo una empresa, que no lo olvide, o sea, no traje por eso. Estoy preocupado porque no si no lo traje. No, no, igual con el cable enchufó la compu también. Ah, no, que de hecho creo que lo perdí, o no lo tengo listo porque no lo usé, no lo necesité. En el hotel enchufo la compu y conecto el cable del celular ahí. No el cable sí, el cargador no. Sí, ya todo lo que la empresa enchufado, acá en la web, está por la ventana de la mesa, The Wi-Fi goes on and off.
It hit me this morning twice. That's why the real time stopped, and I couldn't start it
Yeah.
again without interrupting another time. It's frustrating. Yesterday, I had no problem with it. Just today, I don't know. Maybe because the sun is shining.
Happened to me yesterday a couple of times too. I mean, it was, but it was going back. This
Yeah.
morning, it doesn't seem to be going back. Second attempt at connecting.
Yeah.
Shit.
Well, when I put in the hardwire just now, it dumped the entire transcript into the iPad, so
Did
it's
it?
all caught up. So that there is a blockage in that Wi-Fi.
Now it tells me the server is down. Hello.
I think a bunch of birds are sitting on the wire.
No internet.
No internet, you too, huh?
You too?
I have no internet.
Yeah, see, that's the problem I had, and it really interfered with my signal.
Raffles meeting, pas de connexion internet. Connecté, voilà, c'est
Now it's working.
supposedly.
You're welcome.